Seen on the application of Hani Youssef against Her Majesty's Treasury.
Yeah.
This morning, written submissions from Mr. O'Connor and from myself, together with a bundle.
Louder, please.
Sorry, together with a bundle of authorities. Also, I hope you've received a copy of the draft order which the Treasury invites the court to make. My Lord, as you know, the Treasury's applications are that the effect of the judgment of the court be suspended.
Can I just be quite clear which one it is, Mr. Swift? Is that the one which is dated 28th of January at the end?
I think they're all dated 28th
Oh, are
of
they?
January.
Sorry.
My Lord, do you have a copy with track changes? And
Yes.
the track changes are shown as being made by me and Mr. O'Connor.
Yes.
It's got on the top left-hand corner in capitals draft 27th January 2010.
Yes, that's certainly right. My Lord, what has happened since yesterday is that Mr. Mambro circulated a further version of the draft, and these changes have been made to that version of the draft. So you should have track change boxes down the side of the paper. They should identify who has made the changes, and they'll be made either by Jonathan Swift or by Andrew O'Connor.
There's a colouring code. Is it the colour that tells us who made the changes?
It doesn't identify who did them.
Oh, I see. I'm sorry. Different.
But it doesn't matter as long as you tell us.
Is it, as long as it's the same edition?
Yes.
Are they red?
Probably. Could you look at,
Which ones are earlier ones?
my lords, could I ask you to look at paragraph 5 of the order? Does that paragraph read, paragraph 2 of the order, this order shall not take effect until the 25th of March, and paragraphs 3 and 4 of the order shall not take effect until the 11th of March?
Yes.
My lord, in that case, that is the version.
Yes.
I haven't got that. Where do I find this?
That was in the brand new papers.
Oh, in the brand new papers, I'm sorry, yes.
My lord, that then is the order that we invite the court to make. The written submissions fall into two parts. The first concerns the question of the power to make such an order, which was the point raised, I believe it's the point raised by the court yesterday morning. My lords, we say at paragraph 3 of the written submissions that as a simple matter of vires, it is clear that this court does have the power to do that. Rule 29 of your rules give you all the powers of the court below. The court's powers therefore include the powers of the Court of Appeal under the CPR, and CPR 40.71, which is set out there, states that a judgment or order takes effect from the day when it is given or made, or such later date as the court may specify. So on its face, that is a power to suspend the effect of an order or judgment. It's available to the Court of Appeal, and it is available to you. My lords, we deal briefly with the phrase judgment or order. I won't take this at any length if it's not a point of particular concern to you. It is clear, we say from the authorities, we rely in particular on the judgment of Mr. Justice Lawrence Collins in Re Matthew, that the notion of judgment or order refers to the formal document prepared after the reasons of the court have been given and sealed by the court, which is in effect and in practice the operative document. It is the document that identifies the action that the court requires people to take, or in the case of a declaration, the conclusion of the court as to what the law means, either generally or simply as between the parties.
I'm sorry, I'm a little lost. Is the effect of the order not taking effect here in your submission that these orders are not quashed, but they are simply known by publication yesterday of the judgment to be unlawful?
My Lord, if you grant the suspension that we seek, the effect will be that the orders will remain in force and in effect until the period of suspension comes to an end.
When you say in force, I mean they will not be quashed. You mean, say, if somebody disobeys them, they can be sent to prison?
My Lord, yes, that would be the consequence. They remain in force until the order comes into effect.
What about the past?
What about the what?
What about the past up to now? I mean, are we purporting to deprive them of their rights to, if any, to sue the UK government, for example, under the Human Rights Act for wrongful infringement of their liberties?
Yes, my Lord, I'm glad you raised that point. I wish to make it absolutely clear that the answer is that what we ask you to do now will have no effect whatsoever on the position in that regard, either in relation to the period up to today's date or in relation to the period of any suspension. In that regard, the suspension we seek is an entirely neutral matter.
Well, that, Mr. Swift, speaking for myself, is the problem. I don't have a problem with the question of whether we have jurisdiction to suspend the effect of our order, if our order has any effect at all. My concern is that because our order is declaring unlawful and void the orders that have been made, our order simply recognises the existing position in law. And whether we make that recognition today or in a month's time has no legal effect whatsoever, so that in the month, anyone who disregards the order will not be subject thereafter to a successful prosecution any more than as you've conceded. And I think you conceded that. That goes also for the past, so that our order might be used as if it imposed some kind of temporary fetter on behaviour of banks or of individuals, but if it were so used, it would be contrary to the position in law.
Well, my Lord, again, I don't wish the position to be unclear in any respect. The reason the suspension is sought is so that, pending a short period for Parliament to have a fair opportunity to consider whether to make primary legislation in relation to the present terrorism order provisions and whether to make secondary legislation in relation to the Al-Qaida order, the reason that the suspension is sought is precisely so that during that period, the prohibitions contained in the two orders will remain in effect. Now, my Lord, there are important practical reasons why we ask for that result. Firstly,
I'm speaking myself, I have no doubt there are very strong practical reasons, etc., etc., etc. We're looking to see whether actually there is power to do anything effective such as you seek. And I repeat, I just want to know, assume we do what you want, are you saying that one of these people who tomorrow breaches the order can be prosecuted and imprisoned for it?
well,
And if so, what happens at when the suspension ends? Does he then get released and have a claim for wrongful imprisonment? What happens?
my Lord, the period of suspension that we seek, the periods, are very short periods. My Lord, please, if I may just make the point. The periods are very short periods. In practice, during those periods, the Treasury wishes to maintain, in particular, the asset freezes that exist in relation to these appellants and in relation to the wider group of persons affected by all the terrorism orders and the Al-Qaeda order.
Where are the assets? Are they held by banks?
Correct, my Lord.
Really, the order is directed to banks. So what is the effect on the bank?
My Lord, may I deal first with my Lord Brown's question and then attempt to deal with that question, if I may? My Lord Brown asked, well, if somebody contravened the order during the period of suspension, would that amount to a criminal offence? Well, since the order would be in force, the answer to that question technically would be yes. But, my Lord, the reality of the position is that the period of suspension sought is so short that by the time any prosecution was in any sensible shape or form commenced, it would be obvious by that stage that the orders were ultra vires and the prosecution would not be proceeded with.
Wait a minute. I mean, we've either got to be saying that these orders have some validity which generally we're declaring they don't have, or we haven't. I mean, you can't have, it seems to me, evade the point of principle by saying that in practice banks are going to be frightened and if the individuals manage to breach the order despite that, then in reality it's pretty unlikely and we needn't worry about it.
Well, as I say, I don't shy away from the fact that the effect of the suspension would be that the orders would remain in force for a further short period.
Well, it wouldn't be. The suspension would simply be that there wouldn't be an order for 2 months, which, in ordinary terms, once made in 2 months' time, would actually declare that these orders had always been invalid, including during the period of suspension. That's your problem. What you're asking us to do is to breathe life into something which is invalid for a period of 2 months, at least as regards criminal sanctions, although I think you suggest not as regards the possible right to claim compensation. That's an odd order. I think it's been made. I mean, I think there's quite a lot of authority around the world on this sort of thing, but the actual issue we're addressing doesn't appear to have been focused on closely. But I think you can find precedents for that sort of order.
Well, we have, and they're referred to in the written documents.
Well, there may be one or two more. I came across a case in the Supreme Court of Canada called Chuck Cooey, I think it is.
Yes, well, the Canadian cases are considered by the Hong Kong Final Court of Appeal. For that reason, we...
Yeah, well, I mean, that's the problem anyway.
But my lord, as I say, I think the practical reasons why the suspension is sought are well understood. Yes. Both the point as to the United Kingdom remaining in compliance with its international law and community law obligations, and the point that in relation to each of the designations, whether they are domestic designations or whether they are designations that have been made by the 1267 Committee, in relation to each of those matters, if the persons are immediately freed from restrictions, significant matters of public security will, we say, possibly arise. Certainly the domestic designations are not decisions that are taken lightly and not without due reflection. None of the cases before this court have concerned the factual basis of any of the designations because this case has proceeded through all the courts on preliminary issues rather than dealing with whether there was a factual basis for those designations. So, Mr. Hussain makes my in relation to Hay, the position was slightly different because, of course, before the hearing at first instance, the Secretary of State had already decided that an application would be made to the 1267 Committee. But, my lord, that still makes the point. In relation to the Al-Qaida order, the important matter is the conclusion reached on the merits by the 1267 Committee. In terms, as I understand it, there are two issues that have been raised so far. The first issue is whether, if you made the order that I ask, that order would have any effect at all.
In law?
Yes, in law. As to that issue, if it is accepted that you have the jurisdiction to make an order suspending the effect of the judgment, and we say that there is clear authority to the effect that you do have that jurisdiction, we say as a matter of law, if you make such an order, it will be of legal effect.
Well, it might have an effect in this way, that you would not be in contempt of court if you were to do things consistent with the existing order. And if all we were concerned with is some order directed against you as a party, and there were no third parties involved, that might make some sort of sense. But could I come back to the question about the banks? Because there they are. You say the assets are held and frozen in their hands. And we're saying that anything we may say doesn't shield the government from legal liability for acting in a way that was we said is in breach of fundamental law. So,
Indeed.
And you accept that.
Yes.
And whatever we say about suspension is going to preserve that truth all the way through.
Indeed.
So what is the position of the bank?
In relation to the banks? Well, my lord, the position of the banks during the period of suspension would be the same as if the order were made now, in the sense that if the order is made now, the banks technically, or actually, would be liable to damages claims to the extent they have frozen accounts. The position of the banks during the period of suspension would be precisely the same. Now, in relation to both those periods, if actions were in fact brought against a bank rather than the state, it is obvious in those proceedings that the bank would join the state as the cause of its actions. It would third party the state, and liability ultimately would rest with the state. And so the practical position in the absence of a stay in relation to what has happened to date would be precisely the same as the practical position if you permitted a period of suspension. The only difference would be that the period would be 4 weeks or 6 weeks longer.
I mean, speaking for myself, I wouldn't necessarily accept that once these orders are quashed, the banks are necessarily exposed to liability in respect of the invalidity to that point.
But my Lord, the point is that the position of the banks, again, remains exactly the same. If they were exposed to liability by reason of a quashing order in respect of past acts, no doubt they would seek to pass that liability on to the state as they were acting in accordance with the law assumed to be valid. The effect of the suspension would be entirely neutral on that position, both in relation to the period up to today's date and in relation to any period of suspension from today's date.
Well, I wouldn't necessarily accept that.
Could I just ask a question to which you may not know the answer, but on the assumption that Her Majesty's government does indeed wish to promote remedial activity in Parliament or to get over the problem which it currently faces, is it intended that this should be retrospective?
No.
No.
Prospective.
So it's not intended that somebody is going to say, not only have we power to do this for the future, but we have always had power.
No, correct. So again, underlining the point, the effect of the suspension I ask you to make is entirely neutral in terms of liability for past acts.
Well, that is on the assumption that that's what happens.
Yes.
Were somebody to change their mind and suddenly think, oh, well, that's a neat solution.
Well, my lady, it's a theoretical possibility, but I would suggest a practical impossibility. Such retrospective legislation would be entirely exceptional.
Yes, it would. That's why I asked the question.
Yeah, it has to go through.
To argue that sort of point, is it?
Well, my lord, no. We are seeking only a short period. One can only imagine the practical difficulties that would arise if retrospective legislation were introduced.
It would need to have the sanction of the law officers.
Oh, indeed, yes.
Yeah, if it were to be so. I mean, Mr. Swift, speaking from my own personal experience as a law officer, I can recall occasions when the then government faced decisions of the House of Lords which were going to bring chaos in the social security sphere, particularly, for example. And perhaps the people weren't so ingenious, they didn't think of asking for a suspension of orders. The result was, of course, that actually everybody had a bill ready to go in the event of the House of Lords going against the government.
Yes.
One occasion it actually turned out they didn't, and all that effort was so much scrap paper. Why does it? I mean, why on this occasion is there some particular reason why on this occasion we should be introducing this idea of suspension rather than emergency legislation or whatever it might be?
Well, my lord, yes. One of the key matters identified by my lords in their judgments was concern at the lack of parliamentary scrutiny of the orders made under the 1946 Act. The reason the short periods are sought is so that there is a fair opportunity for Parliament to scrutinise the primary and secondary legislation. I hope you've noted that in relation to the secondary legislation, what is proposed is the use of an affirmative resolution procedure. Now, my lord, I don't know on my feet what the precise practical position is, but no doubt, if necessary, legislation could be put through Parliament very, very quickly. But that is not what the Treasury wishes to do in light of the observations made by this court. My lord, there is a dilemma here. No stay, and some might say the Treasury attempting to promote legislation through Parliament that reinforces precisely the vices identified by this court, a period of suspension. enabling Parliament to have the opportunity fully to consider and, if necessary, and if a possibility, reject the remedial measures proposed by the government. Which of those options is preferable? An entirely rhetorical question, but it's an important matter which I think you must recognise.
But I mean, assume this suspension for whatever, a month. One of those presently affected by the order is advised, he's read the judgment, and he's told, look, this was al-Ghabra. You can ignore the thing entirely. And that's right, isn't it? They can ignore it entirely.
Well, my lord, if you suspend the effect of your judgment, no, that would be wrong.
Well, I'm sorry, I don't understand that.
Well, my lord, could I...
I realise I'm dealing with two people
like
at once, but I
once.
just wanted to put to you
maybe,
an analogy, and then, because it may enable you to deal with both together.
I would like an opportunity at some point for
Of
the
course.
submission, if I may.
Quite right, yes. But can I just put to you this analogy, which is, suppose that a marriage is void. The fact that a court has not granted a decree of nullity makes no difference. A person who marries, again, will not be guilty of bigamy. That's a precise analogy with the situation that we're talking about here, because we're talking about potential criminal liability, yet you can ignore something which on the face of it is valid. It's an example which has been troubling me and is part of the same question that my Lord Brown has been putting to you. Now, I'll shut up.
Sorry, Hani, I didn't mean to give that impression. But the way we attempt to address it in our submissions is this way. Firstly, the practice of the courts in this country and the practice of the courts abroad, we have the example of the Hong Kong decision, is to recognise that it is open to the courts to suspend the effect of a judgment, and that if such an order is made, it is legally effective to do that. Now, my lords, in terms of authorities, there's the practical authority of what happened in this case itself. Following the judgment of Mr. Justice Collins, he made orders, as you appreciate, he quashed both orders, but at the same time suspended the operation of that judgment in those circumstances to permit an appeal to the Court of Appeal to take place.
What was the case about? Did it involve third parties, or was it simply a matter of an order directed against the
This case.
This case. My lord,
Where do we find it?
Mr. Justice Barnes, not Mr. Justice Lawrence.
I beg your pardon, I was thinking referring to Mr. Justice.
no, my lord,
But isn't the position different when the matter can go on appeal? I mean, you know, this is the end of the road.
well, my lord, with respect, it's not materially different. There are two issues. The first is there power to do this? Will it be legally effective if you do it? The second is there a good reason for you to exercise that power? Now, when one is talking about the position between first instance and appeal and so on, often the fact that there is a desire to pursue an appeal is what provides the good reason for exercising the jurisdiction. It is not the thing that actually provides the jurisdiction itself. Now, we are, in the present case, I say that the good reason for exercising the discretion is the matter summarised at the end of the written submissions, relating to the need to have an opportunity, while the present scheme remains in place, an opportunity to attempt to address the consequences of this court's judgment. My lord, can I just take you to the order in G's case, if that helps? If you had the core volume for G.
Well, I haven't got any of the volume.
Well, my lord, in that case, perhaps I can just read you the relevant part.
What page is it?
It's page 45. So at the of the documents at the back. 45 is the order of Mr. Justice Collins. 2, Al-Qaida order quashed. 3, Terrorism order 2006 be quashed. And then 7, the quashing of the orders be stayed pending an appeal to the Court of Appeal, but on terms that for the duration of the stay, the Terrorism order and the Al-Qaida order shall continue to apply in full to the applicants, save for the following amendments to the orders. And so the effect of the suspension was a general effect. Could I also, page 47, my Lord Lord Mance, is the further order that was made by the Court of Appeal pending the hearing before the Court of Appeal. And that was made by Lord Justice Tuckey, and the paragraph 1 of the order says the quashing of the Terrorism Order 2006 and the Al-Qaida Order 2006, ordered by Collins J on 24th April 2008, be stayed until the appeal is determined or further order. So those were the actual orders made in this case. And my Lord, one can see the practical sense of that, because if the court does not have the power to act in the way that I suggest, to suspend the effect of a judgment, in the present case, each of the Terrorism and the Al-Qaida orders would have been lawful until the judgment of Mr. Justice Collins. They then would have been unlawful and void from that point until October 2008, when the judgment of the Court of Appeal was given, and they would then have remained lawful and valid until the judgment of this court.
No, I mean, but the purpose is different when there is an appeal, because the purpose is to avoid some sort of gap period during which, as a result of an order of a lower court, the order hasn't been enforced because it's been quashed.
Well,
you couldn't alter that historically, whereas when you've got to the final court, there's no further possibility of
the reason may be
changing
different.
the
I fully accept that. The reason is different, but in terms of the effect, for example, between the judgment of Mr. Justice Collins and consideration by the Court of Appeal, the order was in force by reason of the suspension, and so the practical effect was precisely the same. So my Lord Brown's question, during that period, if somebody disobeyed the order, would they have committed an offence? The answer would be yes, they would.
No, the answer would be no now. Surely the answer would be no, because we will have set aside the orders below.
I'm sorry, I was explaining the position as at the period between Mr. Justice Collins' order and the Court of Appeal order.
Mr. Swift, Mr. Justice Collins reaches the conclusion that the order is void and is minded to quash it. If he quashes it, the order ceases to be in existence. If the Court of Appeal says he was wrong to quash it, and it was a perfectly valid order, in the period between his judgment and the reinstatement of the order, presumably nobody would commit a criminal offence. And therefore, it makes very good sense to stay the quashing of an order, which will take, temporarily at least, away from the statute book, the effect of that order.
I'm sorry, my Lord, I don't understand.
Been following the concept.
I'm afraid I don't.
Let's imagine that Mr. Justice Collins is quite wrong. There's nothing wrong with the order, but he thinks it's void. Now, if he quashes it, and there's going to be an appeal, between the period that he's quashed it and the period when the Court of Appeal says, no, Mr. Justice Collins was wrong, this order must be reinstated.
But, my Lord, he did quash it.
I know. But we're talking about, does it make sense to stay the effect of the quashing? And in that situation, quashing the order can actually have an effect.
Oh, my Lord, I'm sorry, I now understand the
Yes,
point.
yes.
In terms of would it make sense to do that, for Mr. Justice Collins to do that, that goes to the question of, is there a good reason to exercise the power? It doesn't go to the existence or effectiveness of the power.
Well,
but, my Lord, and the good reason point, we say, is provided by different matters at this stage.
Yes.
In terms of the effect, what was the effect of the suspension by Mr. Justice Collins? My Lord, the effect would be the same as a suspension by this court. albeit, of course, this court will suspend for a fixed period, a short fixed period.
Well, now we know with hindsight that the suspension effected by Mr. Justice Collins had no effect. But had this court ruled that the orders were perfectly valid, then it would have had the effect of preserving the situation.
Well, Manuel, could I invite you to attempt to disentangle the notion of the declaratory nature of the judicial function from the power that I'm inviting you to exercise now? And the reason I say you should do that, Manuel, you'll see in our written argument, we refer to the decision to the judgments of the House of Lords in Re Spectrum Plus. Now, I appreciate...
I hope we're going to look at that, and particularly at the end of paragraph 38 of Lord Nichols' speech.
My Lord, yes, I'm happy to go to it right now.
Just before we go, you have said repeatedly that this court has the power to suspend the effect of its judgment.
Yes.
For myself, I have no problem with that proposition. We have the power. The question is, as a matter of law, has our judgment had any effect at all? And if it hasn't, then there's no point in suspending it.
Well, my Lord, we say that your judgment will have effect when an order is made. We say that is the operative document. That is back to the judgment of Mr. Justice Lawrence Collins in Matthew, referring to the judgment of the Masters of the Rolls, Sir John Everson, in Lake and Lake. That is the first stage. That is why we invite you to make an order suspending the effect of your judgment.
If it's suspending the effect of it would be suspending the effect of an order which we would make. I mean, the question, because the other side want orders. They're not wanting judgments. They're wanting an order.
Well, in precisely so, my Lord, yes.
And what you're asking for is suspend the effect of the order. That's what you're asking.
Yes, my Lord, and I say that if you do that, that will have the effect of if one... I understand the point. You have promulgated a judgment. It is in the public domain. What will be the effect of what I invite you to do on that fact, that reality? The effect will be that the consequences of that judgment will not arise until the period of suspension has come to an end.
You accept that it doesn't provide you with a shield for,
absolutely.
for all time. It's a temporary shield, just simply that remedial action can't be taken until after the suspension.
Yes. Well, yes, and in terms of if one... Yes, and in terms, for example, of protection against liability arising during the period of the suspension, no shield at all. An entirely neutral act.
What is the practical value of it if it's not a shield for any purpose at all?
My Lord, the practical value is that for the limited period, the restrictions in the two orders will remain in force. And so to that extent, people who have been designated under the terrorism order will remain subject to those restrictions. The banks and other institutions that hold their assets will continue to abide by the asset freeze provisions.
The trouble with that is that as a matter of law, if anyone took any steps against them, they could simply say, sorry, these are invalid. And we haven't got the order out of the court yet, but that'll be conclusively shown in 3 weeks' time when the court's order comes.
But we say that the effect of the suspension would mean that the retrospective effect of your judgment would not arise until the period of suspension comes to an end.
Well, but they can ignore it.
Yes.
They can ignore this invalid order. They know it's invalid. We've said so.
How then is the position now different from the position immediately after the judgment of Mr. Justice Collins? He had quashed the orders. He had then suspended the effect of that quashing pending a future event.
Yes, but he only suspended it because, and against the event, that the Court of Appeal reinstated the orders.
Oh, my Lord, yes, but as I say, that goes to whether there was a good reason for doing that. Clearly, a period of suspension is a step that a court will not ordinarily take. It will need to be shown a good reason to do it. The position...
No, it's not just a reason. It's the only effect of his suspension was in the event that the Court of Appeal reversed his decision as to the invalidity and held that they were valid, in which case the effect of this suspension would be consistent with the underlying position. The problem you're asking for is that you're asking for something, call it a suspension, which is inconsistent with the underlying position.
Well, my Lord, we say no more inconsistent than the application, than the request that was made to Mr. Justice Collins.
No, well, yes, I mean, that assumes Mr. Justice Collins is the final court. He was thinking of the possibility, rightly, that he might be wrong.
Oh yes, no, Mr. Of course, that's the reason why he was prepared to accept the submission and make the suspension.
Yes. I mean, one thing I can see would be the effect of a suspension, and that is that it might be, well, it would be more difficult to say that government and other authorities were acting in flagrant breach of an existing court order. On the other hand, since they would know what the validity, or rather invalidity, of the orders was, they might not have much defence in public law to all sorts of civil claims, as you accept.
I thought you accepted that.
Yeah,
Yes.
well, no,
That's right.
yes,
That's why I was wondering what practical value this has at all. I mean, if the position is that third parties, from now on, knowing the state of the law, can simply ignore instructions coming from the officers of the Treasury, what is left?
my Lord, sorry, that's a different point. I wish to make it clear. On the one hand, the order that we seek, the suspension, would not provide any defence in future to any liability arising during the period of suspension. It would simply be a neutral act in that regard. However, the effect of the suspension would be that the orders remained in effect. My Lord,
Remained in effect. But they haven't. They're not in effect. They're ineffective orders.
My Lord, this I think is the point between us, or between me and the court. Our submission is that your judgment will be given effect by an order. That will be the operative act that you perform. Until you make that order, the reasons contained in the judgments have no practical impact. That is why when judgment is handed down, usually the order is made at that time, and that is the act that has the practical effect. I am inviting you, in relation to that order, to suspend its operation. And so, my Lord, the logical conundrum that you identify does not arise. You have given your reasons in your judgments. You will have made an order, and that order will say that the quashing will not take effect until a certain date in the future.
Well, supposing I'm ex-bank and say, well, I've now read the press reports, I've actually got the judgment on the website and so on, I now know that the orders are void, I'm going to release the funds. Are you going to write to the banks and say, don't do that? And
Yes.
if so, what effect is that going to have?
Well, we would write saying the Supreme Court has made an order suspending the effect of its judgment for a short period of time to hold the ring, to enable remedial steps to be attempted, and the effect of the Supreme Court order is that until the end of the suspension period, you should comply with the requirements of the terrorism order and the Al-Qaida order. That would be the response. My Lord, if that wasn't the response, there would be no point in me asking you for this period of suspension.
Can we just look at what Lord Nichols said in that paragraph? Because for my part, I find it presents a difficulty to what you're asking us to do.
My Lord,
Paragraph 38 in Spectrum, which you've copied for us, I think.
yes, it's in the bundle of authorities. It's at tab 5.
Page 699.
My Lord, yes, 38. Well, would it help just to go back a bit in Lord Nichols' speech, just to get the context?
Can I just clarify in my mind one thing before we get there? I mean, I've just had a look at the Hong Kong case, which seems to me rather a clear identification of the possibilities. There's prospective overruling. We're not talking about that because that is an order that something will only have effects for the future. You're not suggesting that. Then there is temporary suspension. Or temporary validity.
So temporary validity.
Temporary validity, and then finally there is suspension.
Yeah.
Now, although you've been using the terminology of suspension, I think you are talking about a type of partial temporary validity. Partial because you're accepting that there could be liability and damages, but temporary validity because you are suggesting that nonetheless the orders must be obeyed and presumably that there might be sanctions for failing to do so. Am I right?
Well, the way the Hong Kong Court of Final Appeal describes suspension, in practice, it is an aspect of temporary validity. Yes. And so,
Can I be clear,
it's not. I'm not asking for anything more than suspension as identified by the Hong Kong Court of Appeal.
Can I be clear? I mean, I haven't had time to read it before, but as I understand it, what was at stake there was telephone tapping by the state without legislation. Is that basically it?
Basically, my lord, yes.
And what the court said was that was unlawful. But what it then said was, okay, but you can go on doing it for another month. We'll suspend the order. You can go on doing it for another month until you can legislate to legitimise it. Mm-hmm. Is that right?
Yes, basically.
So,
yes.
I mean, that's a bit, so that order would stop the Crown being in contempt while it tapped for another month, pending the legislation to make that lawful.
It would stop it being in contempt, but the Hong Kong Court of Appeal was clear to distinguish between what it described as temporary validity, which would prevent during that period the Hong Kong administration being liable for damages.
Yes, it might be liable for damages, but it could go on doing it.
Yes, it wouldn't be a contempt of court.
I absolutely understand that. But that's surely a terribly different situation from here, where if there is any validity left in this, if you ask us to give any continuing validity to this order, people are going to be at risk of criminal sanction. And that's why I want you to look at the end of paragraph 49, paragraph 38 of what Lord Nichols said.
Well, yeah, well, could I ask you to start? Well, I'll come to the Hong Kong case in a minute. I'll attempt to deal with one authority at a time. The Spectrum Plus case, could I invite you just to, before we go to paragraph 38, to look at paragraph 34 and 35 on the previous page. There, Lord Nichols, firstly, important to bear in mind that what the court was considering, what the House was considering in this case, was temporal limitation. That is to say, prospective overruling. A step that is a much more significant step than simply a suspension of the effect of a judgment. That's a very important point.
So you're not asking for prospective overruling?
No, not at all. That would be a temporal limitation. I'm not asking for that at all. But I say the reason it's important to recognise this is what this case was dealing with is that the House there accepted by a majority that there was in principle the power to do that it would be effective if it did that. And my lord, I say it follows a fortiori that if there is the power to limit the temporal effect of a judgment, and if that power, if exercised, is effective, it must be the case in relation to the much less extreme step of a temporary suspension, that there is both the power to do it, and if it is done, it would be an effective measure.
Well, that's why, with great respect, the last sentence of paragraph 38, which Lord Brown draws attention, is very important, because that would suggest that there would be no question of prospective overruling if the effect of that was to continue to expose people to the risk of prosecution during the period that was being contemplated. That would be totally wrong, as I understand the last sentence.
Well, this is argument, isn't it? Lord Nichols at sea says, shows that the House, as he said, has no power to do this, and the rest of the paragraph is argument, and the conclusion is paragraph 39, which I think doesn't accept Har unequivocally. I think Har, I'm not sure, has been followed I think there's an Irish case, Murphy and the Attorney General, the Supreme Court in Ireland, and then there's the Canadian cases, and indeed, in principle, the Hong Kong case. There's a Canadian case called Charcouet, which concerns detention. I think my judicial assistants actually got copies of the pages.
I'm sorry, is that the...
I mean, Har does take a very firm line against you. There's no doubt about that.
I'm just seeing if that is one of the Canadian cases mentioned. No, there was a, yes, Swain was a detention case as well.
No, you see, Sharkui is after the Hong Kong case. Sharkui is 2007.
Well, if I could come back to Spectrum Plus for a moment. The point at paragraphs 34 and 35 was the acceptance by Lord Nichols that the existence of the declaratory theory of the judicial function was not a bar to the possibility of placing temporal limitation, that's to say prospective effect only, on a judgment. At paragraph 35, for present purposes, the distinction between these two types of case is not important. He's referring back to paragraph 34, nor is the declaratory theory. For present purposes, what matters is the practical impact overruling may have in both types of case. The question now under consideration is whether, having regard to this practical impact, it is necessarily and always beyond the competence of the House as the Supreme Court in this country ever to limit the temporal effect of its ruling. And the conclusion he reached on that is at between paragraphs 39 and 41, and was that in principle that power did exist. Now, my lords, in particular, paragraph 41, it says, if altogether exceptionally the House as the country's Supreme Court were to follow this course, I would not regard it as trespassing outside the functions properly to be discharged by the judiciary under this country's constitution. Rigidity in the operation of a legal system is a sign of weakness, not strength. It deprives a legal system of necessary elasticity. Far from achieving a constitutionally exemplary result, it can produce a legal system unable to function effectively in changing times. Never say never is a wise judicial precept in the interest of all citizens of the country. Now, my lord, that, as I say, is considering a much more extreme measure in terms of an order than I am seeking. I am not seeking any temporal limitation of this judgment. All I am seeking is that its effects be suspended for a short period. At the end of that period of suspension, the retrospective effect of the judgment will be as full and as complete as it would be if you made the order without a suspension.
So what changes in the legal order when the court makes its order in this case? I mean, what actually, supposing the court
Made no order.
Made no order at all. Would the legal world relating to this matter be any different from the situation where the court made an order? Because after all, we've been asked to make an order.
Well, my lord, there would be a difference, we say. That is what is clear from the Matthew decision of Mr. Justice Lawrence Collins. It is the order that is the operative document, the operative act, rather, on the part of the court, not the reasons of the court. That is why all courts will always make an order pursuant to a judgment.
Which case is that?
That's Matthew, my lord. In the authorities, it's tab 2. My lord, you get the context of the head note. M was a vexatious litigant against whom a bankruptcy petition had been presented. In a reserved written judgment, after a contested hearing of the petition, the registrar decided the petitioner was entitled to a bankruptcy order, but that the petition should be adjourned and relisted for a further short hearing to enable M to address the court as to his prospects of paying the bankruptcy debt. The registrar extended time for appealing to 14 days from the date of the written judgment. M applied without notice and obtained from the judge permission to appeal pursuant to Section 42 of the Supreme Court Act. In the appeal, the petitioner contended that in the absence of a formal order to appeal against, the court had no jurisdiction to hear any such appeal. Now, this is a short judgment. If I could ask you to look at the top of page 532, third line on that page, the petitioner submits the court has no jurisdiction to hear this appeal because there is no order at the moment to appeal against. What is said is that so far all that has been given is a reasoned judgment, and that there is no order consequent upon it, which could be the subject of an appeal. This matter has been considered in a well-known decision of the Court of Appeal in Lake and Lake, which concerns Section 27 of the Supreme Court of Judicature Act 1925, which gave the Court of Appeal jurisdiction in relation to appeals from any judgment or order of the High Court. In Lake and Lake, the husband had petitioned for divorce on the ground of the wife's adultery and cruelty. The wife denied she'd been guilty of adultery or cruelty, pleaded if she had committed adultery it had been condoned, and cross-prayed for a decree of judicial separation on the ground of the husband's cruelty. The Divorce Commissioner found that the wife had committed adultery, but that it had been condoned, and dismissed the petition. The wife sought to appeal against the finding she had committed adultery, and it was held that because she had won, she could not appeal. Sir Raymond Evershed said that...
I don't think we need to go further.
But you have the point there, that it's the order that's the operative document. It's the order that gives effect to the judgment, and it's the order that is the subject of an appeal. And when one runs out of appeals, as one has in this case, it's the order which gives formal effect to the reasons in the judgment. As my lords have noted, all the parties require you to make an order. Now, firstly, there has to be, we say, as a matter of good practice and public interest, a formal act that disapplies, quashes secondary legislation if that act is to be taken. This is not a situation where the issue is such and the consequences are such that the judgments can be allowed to speak for themselves.
I mean, the question is, yes or no, do you have to obey an order that you know to be invalid, even if the court order, so to speak, crystallising that in final quashing form is delayed? Yes or no, do you have to obey that order in the meantime?
Yes.
Well, I would suggest the answer is, on the authorities, plainly no.
Well, my lord, if the answer is no, the suspension that I seek would have no practical benefit at all. The reason the suspension is sought, well, you understand the reason why the suspension is sought.
It would have practical benefit in practice if you brandished it in front of bank managers and said, look, the Supreme Court has suspended.
Yes.
It would have practical effect because it might mislead the bank manager into thinking he would be committing an offence if he transferred funds, when in fact that wasn't the case.
Well, my lord, no, it wouldn't mislead the bank manager with respect. It would tell the bank manager precisely what the position was, that the order would cease to apply at a specific date in the future, but until that date it remained in force. It would not mislead the bank manager in any way at all.
Sorry to interrupt you. I mean, the position today is we haven't made our order yet.
Yes.
The bank manager knows perfectly well what we said yesterday.
But he doesn't.
And he might have come to you at 8 o'clock this morning and said, look, I want to release these funds. Now, that's, your position is, are you saying that you could still tell him, don't do that because no order has yet been made? Or can he say, I know the order of the capital O, the terrorism order or the AQO, whatever it is bad, and therefore I can just go ahead? Well,
my lord, the answer to that question, had it been asked, would have been, firstly, no order has yet been made by the court. Secondly, an application has been made to suspend the effect of a judgment for a short time. That application is being considered and heard by the court this morning. That would be the answer that would be given.
A freeze would continue, you say, until the order was actually made.
Yes, that is the reason why in every case, regardless of the context, an order is made that puts into effect what the reasons of the judgment require.
Now, I mean, usually, I find it a bit difficult to treat Ree Matthews laying down a general principle, since I would have been astonished if many orders in the commercial court weren't obeyed and weren't capable of enforcement by contempt. If they weren't obeyed, immediately they were made orally. But the ordinary principle is that they're going to be endorsed as made on the date they were made orally. By an order, and your suspension changes that, so that it's really the suspension point that you say makes a difference.
And, my lord, can I show you an example of a decision of the Chancery Division where a period of suspension was granted, not pending an appeal, but pending another event? That's the judgment in Roussillon Frères and Horwood, which is in the bundle at tab 6. This is a judgment of Mr. Justice Warren. Again, if I could take the context from the headnote, the applicant applied to the Trademarks Registry to invalidate 2 UK trademarks registered in the name of the respondent on the ground that there was a likelihood of confusion between those marks and earlier trademarks registered in its name. The hearing officer dismissed the applications and the applicant appealed to the High Court. The appeal was allowed and the applicant was granted a declaration of invalidity. The respondent sought a suspension of the declaration pending decisions on its applications to the registry to invalidate or revoke the applicant's registered marks. On the question whether the court had jurisdiction to suspend the declaration pending resolution of those applications, held a declaration of invalidity resulted in an appropriate entry being made in the register, which could be relied on by everyone and was effectively regarded as irreversible, that it therefore had implications that far exceeded its effects on the parties to the litigation, that the court did have jurisdiction to suspend a declaration of invalidity pending an invalidity revocation application in the Trademarks Registry, and that, in the circumstances, it was appropriate to suspend the declaration to which the applicant was entitled pending resolution of the respondent's applications to the registry.
What are you reading from?
Yes, right.
Oh,
Yes, you've got a different
Yes.
report.
I was reading from electronic printout of the business law report, but
No, it's completely
You've got
different.
the RPC
We've
report.
got the
oh, I see.
Patent cases, yeah.
I'm sorry.
patent cases, which has got a much longer, but not necessarily any clearer headnote, I have to say. The one you read was much clearer.
Can I read something that we'll all have, which is the judgment, and that should be the same in all. I apologise. I hope that was clear there as to what the summary of the case was. In relation to the judgment, first paragraph 2, Mr. Justice Warren recognises that Roussillon Frere is entitled to declaratory relief to reflect his judgment. He says that is to say, a declaration that Horwood Homeware's marks are invalid so far as concerns Class 8. And paragraph 3, Mr. Van Hagen, he appeared for the applicant, accepts that I have power to grant a stay, or at least to effect what amounts to a stay, for instance, by delaying the grant of the declaration of my decision pending appeal. But the power to do so is, according to him, to be found in CPR 52 concerning appeals. He submits I have no other power to suspend the effect of my decision, and in particular I have no power to do so pending HH's invalidity revocation applications. If he is wrong on that, he submits that I should decline to exercise that power. Mr. Arnold submits both I do have such a power and that I should exercise it by suspending the effect of the declaratory relief. Paragraph 4, again referring to Mr. Van Hagen's submissions, paragraph 5, paragraph 4, the third sentence, the judge says, rather we are concerned with the postponement of the practical effect of any declaration. So that's what he's concerned with. Paragraph 5, the court does not, however, have a general power to suspend the execution or enforcement of its judgments. Mr. Van Hagen relies on TC trustees in Darwin to establish the proposition the court can stay execution only on grounds that are relevant to a stay. It does not extend to grounds which are properly matters of defence, of law, or relief in equity, since these are matters which should be raised in the action itself. I would pause there just to say that that is a limitation that is not relevant to the circumstances of this case. At paragraph 6, Mr. Justice Warren refers to the judgment of Mr. Justice Lightman in Second Sight and Novell, UK Limited. And the passage quoted from Mr. Justice Lightman, when a plaintiff has a prima facie right to damages and an injunction restraining infringement, but the defendant has an outstanding application for registration, which will give rise to a backdated defence if successful, what course should the court adopt? The authorities show the court may adopt any of three alternatives. 1, the court may grant a stay of the proceedings for infringement pending the outcome of the application for registration. 2, the court may allow the case to proceed to trial and after judgment consider the grant of a suspension of any order made pending the outcome of the application, as in Electrolux and Electrics. And there's a third option, granted for relief. Paragraph 7, the second alternative recognises the possibility of suspending any order made. If I could ask you to go now to paragraph 13, where a further submission is considered. 13.
Sorry, I just noticed the reference there to a backdated defence if successful. I mean, I don't know anything about this area of intellectual property, but was that a possibility in that case? That there would be a backdated effect of whatever it was they were going to wait for?
It would appear so, yes.
Well, then, I mean, that's a completely different situation.
Well,
It's a sort of appeal type situation because the claim which succeeded could be undermined. The claim which succeeded was based on the proposition that the claimant had 3 earlier registrations, that could be undermined by later proceedings which set aside those registrations.
My Lord, I'm taking you to this authority for a rather different proposition. It's put to me that there's no point in making a suspension because it would have no effect. The cat is out of the bag because the reasons have been given. That's the point I'm trying to address. This judgment clearly indicates that is not the position. That in fact, even when the court, as Mr. Justice Warren recognised at the outset, by reason of the reasons it has given, the reasons are such that the claimant is entitled to declaratory relief. Nevertheless, in those circumstances, for reasons that are not directly connected to the litigation before the court, but connected to the consequence of the court's declaration, in those circumstances, the court can suspend the effect of its declaration. It's important to note that this was not a situation pending an appeal. It was a situation, the situation was, should the register be amended in accordance with the declaration for all purposes, as against all persons, regardless of the effect of that, or should a period of suspension be permitted to enable a different claim before the trademark registry to be pursued and determined. But at paragraphs 13 and 14, Mr. Justice Warren directly confronts an argument as to the need and effectiveness of a suspension. Paragraph 13, he says, next Mr. Van Hagen submits that a direct declaration is complete in itself and requires no enforcement. I suppose that it should then follow that since there is no need for enforcement, there is no scope for stay. In the case of a declaration having effect only between the parties, that may ordinarily be so, but even in such a case, the court must surely have, at least pending an appeal, a jurisdiction to prevent possibly irrevocable action being taken in reliance upon the declaration. So far as concerns a declaration of invalidity or an order for revocation, it needs to be remembered that the declaration which RF is entitled to has an impact which goes far beyond the parties to this litigation. A registered trademark is a property right, enforceable against the world. A declaration of invalidity will result in an appropriate entry being made in the register, which can be relied on by everyone and is effectively regarded as irreversible. It is not disputed that pending an appeal, orders for revocation and declarations of invalidity are often suspended. Certainly there is jurisdiction to do so. He then considers the position pending appeal. And at paragraph 15, given that the jurisdiction exists pending an appeal, I see no reason to doubt that the jurisdiction is available in other circumstances, provided it does not go beyond the boundaries explained in TC Trustees and Darwin. That's a reference back to paragraph 5 of the judgment. And then at paragraph 17, the upshot of all this is, in my judgment, the court does have the power to suspend the declaration to which RF is entitled in the manner contended for by Mr. Arnold. And so one sees in a very different context the court accepting the practical need to be able to suspend the effect of a declaration and recognising that if it suspended its effect, regardless of the reasons contained in the judgment, that suspension would be effective as a matter of law.
And that was with a view to remedial action being taken to put the matter properly on the register. And if it was on the register, would that have retrospective effect? I mean, I don't know enough about it to be sure whether that was a feature of the case. That rather like an appeal which turns out to be successful, you wouldn't want to have action taken in the meantime which would deprive the successful appellant of the benefits of his appeal. And it may be this kind of undercurrent as in this case.
Well, I'm sorry, I'm on my feet. I'm not able to give you the answer to that question. I'd need to do a bit more research. I'm sorry, my lord?
It's rather an important question. I mean,
yes. I'm simply saying I don't know the answer to it now, but I will find it out for you.
Well, presumably, if the earlier registrations upon which the success of this action depended were themselves set aside upon the defendant's applications to invalidate or revoke them, even though I see it was said it might take 8 years to do so, then presumably the result of this action would be revisited. So it is a sort of appeal-type situation.
I mean, I think thinking it through, the point is that nobody else can get onto the register with this invention or whatever it is, so long as there's an entry on the register. And the entry that's being talked about here is bad, but it's being kept there to keep other people off until a proper entry is put on. Maybe that's the scenario.
Well,
in this case.
isn't it the reverse? That in fact the entry remains on rather than being taken off until the
Yes,
outcome
that's
of
right.
the
That's
other
what I mean.
proceedings.
Yes, it remains on, but then it'll be replaced by a good one. But in the meantime,
Well,
nobody else can get on.
Possibly, it remains on pending the separate application, the effect of the cross application in different proceedings. But my lord, one of the points that is put to me today is, well, what's the point of making the order that I seek? Because it would have no effect. This case is an example in a very different context of the important practical effect that such a suspension will have in practice. And I come back to the point that if you have jurisdiction to make such an order, and I say it is clear that you do, if you exercise that jurisdiction and make the order, it will have legal effect. That is a necessary consequence of the existence of the jurisdiction. It will certainly have practical effect, and so it would not be a situation where this court took a formal step to identify a particular legal state of affairs and it was simply ignored by the entire population. It would have practical effect because, as I say, insofar as the effect of the 2006 orders is to freeze the assets of designated persons and so directed in that sense to banks and other financial institutions, those financial institutions would act in accordance with the order of this court.
Yes.
That is entirely predictable. My lords, is now a convenient moment to go to the Hong Kong case?
Yes.
Thank you. That's in the bundle of authorities at tab 7. Now, again, just to set this in context, we have relied on the judgments in Re Spectrum Plus for the proposition that if, as is accepted in that case, this court could impose temporal limitations on a judgment and those limitations would be effective, it inevitably follows that this court could take the less extreme step of suspending the effect of a judgment and that suspension would be effective. So that's why we rely on Spectrum Plus. The judgment in Yu and Chief Executive of Hong Kong Special Administrative Region concerns a situation where the court did grant a suspension of a judgment. My lord, for the circumstances in which it arose, could I ask you to go to the start at the very first paragraph of Mr. Justice Bukhari's judgment? He sets out the questions there. Can a court ever, and if so, under what circumstances, make an order according temporary validity to a law or executive action which it is declared unconstitutional? Pausing there, not a relevant question for the purposes of my application. Failing such an order, can a court ever, and if so, under what circumstances, suspend such a declaration so as to postpone its coming into operation? That is the point that arises in this case. It says those are the questions of law which have reached us in this case. The context is covert surveillance, and the conditions found to be incompatible with freedom and privacy of communication as constitutionally guaranteed. And he then identifies Article 30 of the Basic Law, which was the constitutional provision. To get the history of the matter, paragraph 4, the Interception of Communications Ordinance was made in 1997. When in force, it would have repealed Section 33 of the Telecommunications Ordinance, but in fact, the 1997 Ordinance had not and has not come into effect. And then paragraph 6, Section 33 of the Telecommunications Ordinance is then set out, and the judge states that the omission to bring the 1997 Ordinance into operation left Section 33 on the statute book. Then 7, doubts over the constitutionality of covert surveillance as practiced by law enforcement agencies in Hong Kong have been growing over the years. Such doubts developed into an acute problem by reason of what the District Court said in 2 criminal cases in 2005. On 5th August 2005, with a view to coping with this problem by way of an interim measure pending corrective legislation, the Chief Executive published an executive order meant to serve as a set of legal procedures for the purposes of Article 30 of the Basic Law. Then at paragraph 10, within a very short time of its publication, the executive order came under challenge in the judicial review proceedings, out of which the present appeal arises. And you see that the claimants attacked the executive order, section 33 of the telecommunications order, and the chief executive's omission to bring the 1997 ordinance into operation. And then at 12, on 9th February 2006, the High Court gave judgment against Mr. Leung and Mr. Koo on the IOCO, finding nothing unlawful in the omission to bring it into operation. So that's a third challenge. But he gave judgment in their favour on the executive order and on section 33. His declarations thereon were to the following effect. The executive order comprises administrative directions only and does not constitute a set of legal procedures for the purposes of Article 30 of the Basic Law, and Section 33 of the Telecommunications Ordinance is unconstitutional insofar as it authorises access to or the disclosure of the contents of any message or class of messages. And 13, at the same time, and to provide a 6-month stopgap measure pending corrective legislation, Mr. Justice Hartman made at the government's request what I would describe as a temporary validity order, doing so in the following terms. Notwithstanding the judgment of the court and the declarations herein, section 33 of the Telecommunications Ordinance and the executive order are valid and of legal effect for a period of 6 months from the date hereof, the parties having liberty to apply.
And you're not asking for that?
No. And as we go on, I think it's important we'll see the distinction this court drew between what it described as temporary validity and what it described as suspension. And it's important to note that what I seek is the suspension as identified by this court in terms of the consequences of the order.
Except that I don't think they consider the question of criminal liability that we have been raising with you.
No, my lady, I don't think that point arose squarely.
It doesn't arise in that case.
It's not addressed in the judgment.
It does arise in this.
Yes. My lords, then from paragraph 19, declaring a law or executive action unconstitutional does not normally leave any void in the legal order, let alone a void that dissolves society or imperils the rule of law. The effect of such a striking down may be purely to rid the legal order of an unconstitutional encrustation. That would be normal. So would striking down an unconstitutional way of doing something that would be worthwhile if done constitutionally. In such a situation, corrective legislation would be a likely sequel. Mere inconvenience in the meantime would not, however, justify temporary validity or suspension. But what if the circumstances are exceptional and the problem goes well beyond mere inconvenience? The judge then reviews a number of, a range of comparative case law. He refers to 2 decisions of the Federal Court of Pakistan and 3 Canadian Supreme Court decisions. The 2 Pakistani cases are dealt with paragraphs 21 and 22. I would suggest that the facts of those cases and the issues arising are not really directly in point for present purposes. Then there is reference to the 3 Canadian cases. The Manitoba language rights case, paragraph 23, you see from there, looking at the 4th line, since 1890, nearly all of Manitoba's statutes have been enacted in English only, but Section 23 of the Manitoba Act 1870, which was entrenched in the Constitution of Canada, required that Manitoba legislation be printed and published in both English and French. One of the questions put to the Supreme Court of Canada was whether Manitoba statutes and regulations not printed and published in both languages were invalid. The court held they were invalid, but they would be deemed temporarily valid for the minimum period of time necessary for their translation, reenactment, printing and publication. Explaining the dire necessity for that court, the court said that it is only in this way that the legal chaos can be avoided and the rule of law preserved.
Presumably a lot of those statutes actually imposed penalties.
Well, given the passage of time since 1870, one would assume that they, 1870, they actually contained the substantial body of law in Manitoba. Paragraph 24.
Well, it was a very, very dramatic situation.
Yes,
Hard to imagine anything more dramatic.
well, my lady, yes. I don't say that these Canadian cases provide a template for these facts, for the facts of this case. What I do say, I take them to you, take you to them rather, simply to identify the issues of principle that arise. At paragraph 24, an important distinction is drawn by the judge. He says, in some circumstances, the doctrine of necessity is involved as a source of jurisdiction and confers on the court powers that are exceptional to the point of being anomalous. And perhaps the Manitoba example is such a case. But in other circumstances, necessity comes into the picture only in the sense of providing justification in any given case for exercising jurisdiction that the court has without recourse to the doctrine of necessity. And then 25 refers to Swain's case. That was a situation where detention of the mentally ill provided under the criminal code, the relevant provision was declared unconstitutional as contrary to the Charter, and therefore declared to be of no force and effect. And then 6 lines from the end of the paragraph, at the same time, the court acted to avert the danger to the public of all insanity acquittees being immediately released into the community. The way in which the court chose to avert that danger was by according the detention provision 6 months temporary validity for corrective legislation to be enacted. Could not the danger have been averted, I feel bound to ask myself, by suspension instead. And then suspension was the course adopted in Schachter's case, which concerned legislation conferring benefits. Regarding those benefits under-inclusive, the Supreme Court of Canada declared that regarding those benefits as under-inclusive, the Supreme Court of Canada declared that legislation unconstitutional. But the court suspended the declaration pending corrective legislation, either cancelling the benefits or extending them. Speaking for himself and four of the other 6 judges, Chief Justice Lamer said this.
Lamer.
I'm sorry, my Lord.
Lamer.
French-Canadian.
I'm sorry, my grasp of language only extends to English. I apologise to him. A court may strike down legislation or a legislative provision, but suspend the effect of that declaration until Parliament or the provincial legislature has had an opportunity to fill the void. This approach is clearly appropriate where the striking down of a provision poses a potential danger to the public or otherwise threatens the rule of law. It may also be appropriate to cases of under-inclusiveness as opposed to over-breadth. While pausing there, my Lord Mance has referred to a further Canadian case, which is Charcowie. I'll probably strangled that as well. In that case, as I understand it, the Supreme Court held that an act that provided for, among other matters, the detention of those subject to deportation proceedings was unlawful. But again, it suspended its declaration to that effect for 1 year for the purpose of giving Parliament time to amend the law. And important to note that those who were to be deported apparently remained in detention during that period. And so what one sees that in that case...
Yes, that's right. It was unlawful because the detention process was on the minister's certificate and rather similar to Cardi and the substantive points in this case. And there was the procedure for challenging the certificate was not a proper procedure, unconstitutional. The detention was therefore unlawful, but they said that the procedure should continue to apply for a year and the detention, no doubt.
And so on that basis, those already detained remain detained. One might think a serious interference with their rights under the Charter. The practices for detention, the procedures for detention, remained in force during that period and continued to be in operation. And so to that extent, one sees suspension as having the effect, as I've suggested in this case, it would have the effect, that the orders remain in force, clearly, in this case, for a much shorter period than the period permitted by the...
Have we got that, Ken?
Well, I don't have a copy of it with me now, I'm sorry.
The Charcowie one, I thought my leave...
We don't think we've got it.
We haven't got it, I think.
It's just there's just a loose summary.
Yes, we've got it.
Yes, that's fine.
Where is it got to?
It's in the sheets which Lord Mance distributed this morning.
Oh, I didn't get a copy.
No, is it this extract?
Yes, that's right.
It comprises
It's only the beginning and the
it's
end.
the head note and the short extract from the judgments.
Yeah,
Yes.
well, I wasn't party to this distribution.
Well, part of the point is that Canadians have been doing this for so long that they don't exactly talk very much about it, do they? Certainly from the extracts that we've got.
Well,
There isn't a prolonged consideration, but it is something that the Canadians have done, as I say, in so many cases.
Yes.
Perhaps they don't think it's necessary. But the effects were draconian in that case.
Can I pass that to Lord Hope?
Is it a spare copy?
Well, no, but it's
You want Lord Phillips, Senior?
I have it by heart.
Yeah, please do have a look.
So I think at least two, you have there the head note and some extracts from one of the judgments, and the paragraphs I think that Lord Mance has in mind are paragraphs 139 and 140.
Yeah.
139.
The head note explains the facts, and
Right.
the reasoning is right at the end.
Well, coming back to the judgment in you and Chief Executive, paragraph 27, the judge there refers to dictum of Lord Nichols in Bellinger and Bellinger, again in different circumstances. That, of course, was in the context of an argument as to whether or not a declaration of incompatibility should be made. But the point of principle is extracted by the judge, or at least an expression of principle. And then 28, the rule of law involves meeting the needs of law and order. It involves providing a legal system able to function effectively. In order to meet those needs and preserve that ability, it must be recognised that exceptional circumstances may call for exceptional judicial measures. Temporary validity or suspension are examples of what courts have seen as such measures. There are other examples, and then an example is given. There's then a reference to Re-Spectrum Plus and Lord Nichols' statement against rigidity in the operation of the legal system, on the basis that such rigidity prevents the legal system functioning effectively. Then at paragraph 30, setting out I think referring to arguments made against the application either for a stay or for an order for temporary validity, starts off by saying, I should read the English of this, let justice be done though the heavens fall, that is the saying. Its underlying idea is succinctly put in Jowett's Dictionary of English Law: a court must do its duty without regard to the consequences. The reference given in Jowett is that it is to what was said on the point in Crown against Wilkes. There, Chief Justice Mansfield said, "We must not regard political consequences, how formidable soever they might be. If rebellion were the certain consequence, we are bound to say, fiat justitia ruet coelum." That goes to doing justice, and then there arises the question of what justice requires. The next point made in paragraph 31, at the top of page 13, is the statement that plainly the substance of a legal doctrine is to be found not merely in its theoretical formulation, but in its practical application pursuant to such formulation. An older and more picturesque statement of the same point is to be found in Crask and Johnson, where Chief Justice Coke said, the application is the life of a rule. The judge then refers to temporary validity. Again, I don't go to take you in detail to that, because that's not what I see. But you'll see that the distinction that the judge drew between temporary validity and suspension was that during that period, not only was the executive permitted to function pursuant to what had been declared unconstitutional, but also it was shielded from legal liability for doing that during the period. Suspension is then dealt with from 34. 34, the judge states the conclusion he sees no grounds justifying temporary validity in the case before him. 35, this leaves the question of suspension, which would not involve the shield to which I have been referring. The judicial power to suspend the operation of a declaration is a concomitant of the power to make the declaration in the first place. It is within the inherent jurisdiction. There is no need to resort to the doctrine of necessity for the power. necessity comes into the picture only in its ordinary sense, not to create the power, but only for its relevance to the question of whether the power should be exercised in a given case. And pausing there, I say that reflects the distinction I've suggested to you between the question of does the power exist and is there good reason for the exercise of the power in this case. And then at 36, the judge continued, in terms of danger to the public, the circumstances of the present case more closely resemble those of Swain's case than those of the other decided cases which we have seen. Those cases include yet another case before the Supreme Court of Canada, namely Crown and Feeney. There, a declaration relating to the requirement of a warrant to search a dwelling was suspended for an initial period of 6 months. Then it was suspended for a further period of 1 month, or until corrective legislation was enacted if such enactment occurred earlier. That is not to say that there are no differences between the circumstances of Swain's case and those of the present case. As to the differences between them, I would mention two in particular. The first difference is that the danger to be averted by according temporary validity is the more obvious in Swain's case than in the present case. Everyone can easily see the danger involved in the immediate release into the community of insane persons of violent tendencies. But the actual matters involved in covert surveillance at any given time is not generally known. The second difference is that an unconstitutional impact on freedom of the person is even more serious than an unconstitutional impact on freedom and privacy of communication. So a court would naturally be even more reluctant to accord temporary validity or suspension to the former than to the latter. As I see it, the upshot is that the first difference points in one direction while the second difference points in the opposite direction, and the two tend to cancel each other out. There is then a reference again to the speech of Lord Nichols in Spectrum, and then at paragraph 41, whether or not to suspend in any given case is a question to be decided with that in mind. In that case I should read 40 as well. In Spectrum Plus, Lord Nichols pointed out that the decision in Manitoba involved having regard to unwritten postulates such as the principle of the rule of law. Sometimes the danger to be averted by suspension will be of such a magnitude that suspension of a declaration of unconstitutionality would not offend against the rule of law. Whether or not to suspend in any given case is a question to be decided with that in mind, and it will be decided by an independent judiciary after a full, fair and open hearing and with reasons given. Suspension would not be accorded if it is unnecessary, and it would not be accorded for longer than necessary. As Lord Mansfield so neatly put it in the proceedings against George Stratton, necessity will not justify going further than necessity obliges. Paragraph 42, the judge addressed the question of whether there was any viable alternative and reached the conclusion that there was no viable alternative. Paragraphs 43 to 44, he considered the question of duration in the case before him. And at paragraphs 45, from paragraph 45, he considers the circumstances of the case and concludes at paragraph 47 that he was of the view that the danger to be averted in the present case is of a sufficient magnitude to justify suspension. Could I also invite you to look at a short passage in the concurring judgment of Sir Anthony Mason? That judgment starts at paragraph 55, and he too, in the judgment, refers to the Canadian cases. You will note that at paragraph 56, he expresses some doubt as to whether the Canadian cases did, in fact, draw the distinction between temporary validity and suspension that the Hong Kong Court of Appeal had drawn. But nevertheless, at paragraph 60, he says, although I agree that a court should not postpone the making of a declaration of invalidity unless it is necessary to do so, the level of necessity in such a case is substantially lower than the level of necessity which would be required before a court would make an order for temporary validity, assuming the court to have power to make such an order. So overall, the Hong Kong Court of Appeal addressing a situation materially similar to the situation before this court.
Well, is that right? The Hong Kong Court of Appeal was addressing a situation where the government wanted to feel that it could go on doing something, which it could do by itself, telephone tapping. So there was no injunction and there was actually no declaration saying for a period, you're saying you can't do that. But in the present case, we're not actually concerned with the government doing something, are we? We're actually concerned with the individuals obeying freezing restrictions and banks.
In the Hong Kong case, I would suggest it's not just a question of the government continuing to do something. Clearly, what the government did by continuing surveillance, covert surveillance operations, was likely to have practical consequences in terms of actions that the police and other government authorities would take based on the outcome of those surveillance activities. And so I don't think it's correct to say.
So all state authorities could go on doing something.
And and no doubt act on the basis of information received.
And be liable,
Yes. Yes.
subsequently, for doing that.
That was the conclusion reached by the court, yes. But
What's the analogy with this case? How's
Well, are you saying they could continue to designate? I mean, assume that the Sanctions Committee put somebody else on the list. Government entitled then, pursuant to the Al-Qaida order, to give instant effect to that.
Well, there's a distinction to be drawn between the Al-Qaida order and the terrorism order. Under the Al-Qaida order, if the 1267 committee designates a person, the effect of Article 3(1)b, as the court has stated, is that the order applies to that person without more.
And so it would affect a new person?
My Lord, yes, it would.
Affecting domestic law through that route.
Yes, my Lord. The terrorism order is a different proposition. The terrorism order 2006, it is a domestic decision to designate a person under that order. There would be no further designations under the terrorism order 2006.
No.
Terrorism order 2009 clearly exists subject to action before the administrative court in light of the reasons given by this court.
The logic of your proposition is that is a good example of an order under which the government could do something. You're saying, are you, that the suspension of the declaration would mean that the government could designate someone under the 2009 order?
My Lord,
on the grounds of reasonable suspicion?
my Lord,
Alone?
again, answering the question at the level of principle, I think that at the level of principle, the answer given would need to be yes. I think it is also fair to say, again, the application I'm making rests almost entirely, at least the reason for it, on practical considerations. In practice, given the short period of time that is asked by way of suspension, it is very unlikely that the 2009 order power to designate a person would be used unless the circumstances were genuinely exceptional. The court appreciates that the standard for designation under the 2009 order, reasonable suspicion that somebody commits terrorist acts, is engaged in terrorism or facilitates the commission of terrorist acts. Now, I would say it is self-evident that for so long as that power remains, it is almost the obligation of the government, in exercise of its obligations to protect the safety of its citizens, that if a strong case comes before it, that a particular person is acting in that way, and freezing their assets would serve to prevent that action, yes, the government will take that step. But it would be I think it's fair to say in practice it would be an exceptional case that would go down that route in the period of suspension that I invite you to grant. But I don't ask you to disregard the practicalities of this, the practicalities of the reason why the application is made.
I mean, I just throw it out as a thought. I mean, I wonder if you couldn't use the 1946 Act to make an order just to hold the position.
Absolutely.
Well, my lords, isn't this...
Well, I'm glad to find some support for that.
I mean, that's what I certainly said in my
Yes.
judgment, that a temporary thing would raise very different matters. And if it was just a temporary order under the 1946 Act, I could see that might very well be all right.
Well, my lord, the Treasury, the government as a whole, it goes without saying, takes very seriously what this court says in the course of its judgments. One point that was crystal clear from the judgments of the court was the concern that by using delegated powers, the full consequences of a measure such as the terrorism order had not been squarely confronted by Parliament. That is what the Treasury wishes to do now. But whether one could say that a 1946 Act order made now was in fact a temporary order, might I suggest there would be an element of unreality about that. Yes, it would be temporary, as it were, from now to the time that further remedial action were taken, but temporary in the sense of something made in 2010 that simply perpetuated something that had been in place since 2001. Again, that order, if it were made, would need to be made very quickly. It would be made without any significant parliamentary opportunity for consideration at all. And that is a course of action that my client does not wish to take unless it is forced to do so.
It seems to be in the teeth of what, at least I was saying in paragraph 60, which is that the basic objection is imposing restrictions on the ground of reasonable suspicion only, which is what you would be doing.
Well, indeed. My lords, the point, there is much to be learned from the 5 judgments given by this court in terms of the different aspects that are emphasised in different judgments. All those matters can be properly considered if there is a short period of time for parliamentary consideration of primary legislation. If there is no suspension, and if it is thought necessary in the public interest to take immediate action, those matters will not be considered at that point in time, and for a further period, whatever short period it is, one would have the same matters in force on the basis of a 1946 Act order. And although I accept my Lord Roger makes the point that perhaps one could use the standard of reasonable suspicion for a temporary period, I didn't read the judgment by Lord Hope as accepting that necessarily. I didn't read the judgment by Lord Brown accepting that necessarily. Nor did I read the judgment of my Lord Mance accepting it necessarily.
I know, but you want us to go on giving effect to the reasonable suspicion approach, rather than you do it yourself under a 46 Act order? No.
I'm sorry, my hearing's important.
No,
I'm sorry.
But, I mean, if you made the 1946 Act order on this short-term basis, of course, no doubt it would be, as far as the terrorism order is concerned, on a reasonable suspicion basis.
Yes.
Which we have found objectionable, well, the majority certainly. But you're asking us, in effect, to save you the need to do that by ourselves giving it the same, producing that same consequence.
Well, yes, but put another way, it is put to me, why are you asking for a suspension when you could make a 1946 Act order?
Yeah.
And my response to that point is that is not a satisfactory way of proceeding in light of the reasons given by my lords in their judgments.
Well, it certainly wouldn't provide a shield, would it? Because we would say it was bad on the ground that I mentioned in paragraph 60.
Well, indeed, and the next person would say, well, Lord Roger is the only person who speaks about the significance of the temporary nature of a restriction together with a standard of proof based on reasonable suspicion. None of the other judgments speak of that.
Well, I think, actually, with respect, don't I point to one of the Commonwealth countries doing precisely that? They allowed reasonable suspicion on a short-term basis.
Australia, was it?
My lord,
To begin with,
you
that
did,
was,
of course,
that
yes.
was the case.
Yes.
Yes.
But again, as I say, well, the short answer to why not make a 1946 Act order is simply that in light of the contents of the judgments, that is not thought to be an appropriate way to proceed. That proper parliamentary opportunity should be given, albeit in a short period. Primary legislation should confront the point directly, and that is the best, the preferable, and the lawful way to proceed. In order to permit that to happen, my client, the government, asks for a short period of suspension.
I suppose one alternative might be to go with a short Act of Parliament or a short bill, just asking for the matter to be held under direction of Parliament rather than by us. I mean, is that not possible? I mean, some kind of short a bill simply for a period, holding the matter until you can.
And so effectively put 2 pieces of primary legislation through
Yes, that's
Parliament.
right. I mean, that's what I'm suggesting.
Before the end
Yes.
of Parliament in March.
The first one being a very temporary one I mean, it's a pretty absurd suggestion, but Parliament can do whatever it wants, and the executive can control the House of
the
Commons.
one
at
thing
least.
Parliament can't do is stop the calendar running.
Yeah.
And with respect, it is an absurd suggestion. With respect, this point needs to be addressed in some way, head on by Parliament. That is the conclusion you've reached. That is what the Treasury wishes to do. It wishes to do that in a situation where the ring is held so that international obligations are observed, community law is observed, and persons who have been designated because it is believed or suspected on reasonable grounds that they are engaged in committing, facilitating and participating in acts of terrorism in the United Kingdom, they should remain subject to freezing orders. That is what the Treasury wishes to be the position for this very short period. My Lord, we say this strikes directly at the points made by Lord Nichols in his speech, encouraging or saying that the law must be operated and applied in an effective way, that never say never is the principle that must always be in the mind of a judge, and this must be a situation where the court should be prepared to consider the possibility of making a suspension order, not, at the very least, not rejecting the application on the basis that it's simply beyond its powers, ineffective. That if the court did this, it simply had no effect at all. With respect, that is a counsel of despair, as well as being a suggestion that's entirely incorrect. In relation to the reasons why the short period of suspension is sought, those are matters, you've seen them summarised towards the end of our written submissions, from paragraph 12 onwards.
Before you go to the reasons, there's one other authority which is relevant and helps you in some sense, isn't there? And that is the decision of the European Court of Justice in Cardi, because having annulled Regulation 881, the court went on to say that because of the consequences and because of the possibility that the imposition of similar measures might, after all, prove to be justified, they would suspend. They said in these circumstances, Article 231 EC will be correctly applied in maintaining the effects of the contested regulation so far as concerns the appellants for a period that may not exceed 3 months running from the date of delivery of this judgment. Yes. So that since the regulation requires criminal sanctions to be applied by member states, the European Court was effectively saying that for 3 months the appellants were to be subject to the regulation and to the criminal sanctions.
Yes. And it was also saying that to the extent that there were persons other than the appellants who had been included in the annex to the order because they had been identified and designated by the 1267 Committee, even though, as regards procedural rights, they would be in precisely the same position as the appellants, nevertheless, they should remain subject to the restrictions and the enforcement measures consequent upon Regulation 881.
Well, that seems to follow from the fact that they only annulled the contested regulation as far as concerns the appellants, so that as far as everyone else, it was to remain in force.
Yes. And so, again, one can see that conclusion, that approach, again, is an approach that is much more intrusive, more extreme.
Presumably, I mean, that's a completely different system of law, and they don't have the principle whereby once we declare something to be ultra vires, it is to be regarded as having no effect at any stage.
Oh, my Lord, they do. The Court of Justice has made it clear that when a judgment is given, unless the court states that there is to be some form of temporal restriction on that judgment, that it is declaratory of the law as it has always been. I'm sorry, but then in Cardi, the effect of their order means that everything that went on up to the time, and indeed for a further 3 months, is hunky-dory, it's fine. There's no question of any reparation in respect of all that. But you're not contending for that position here. I have to say, I'm not sure that
they did decide that.
I'm not sure the hunky-dory point was decided.
I think they were simply saying that for the next 3 months, this is the position. Yes. And weren't prejudging.
So to that extent, the court was actually doing something closely akin to what the Treasury seeks in this case, and say simply action that held the ring. My Lords, I was turning to the grounds on which we seek the suspension, if I may, if that assists. You'll see that the starting point for the submission were the observations in the judgments of Lord Hope and Lord Mance. Each, so far as we understand those judgments, accepted that there should be a suspension of the judgment in relation to the 2006 order vis-à-vis HAY. Youssef. I assume that the reason for that was that it was recognised that until such time as Youssef was removed by the 1267 committee from its own list of designated persons, well then the United Kingdom was required as a matter of international law to apply the restrictions required by the Security Council to HAY. The reason why a similar suspension was not suggested in relation to G, as we understand it, was that he, in any event, has been designated under the terrorism order. And so to that extent, by reason of the 2009 order, is subject to a regime of restrictions materially identical. Yeah. And so to that extent, although G would not be subject to the provisions of the Al-Qaida order, the obligation under international law to apply restrictions to G would be met pro tem by the designation under the 2009 order. And again, in relation to A, K and M, the reason why no suspension was suggested of the application of the judgment vis-à-vis the 2006 order, again, was simply that they too had been designated under the 2009 order, and that order was not a matter formally before this court. And so the overall effect, as we understood it, of the proposals by Lord Hope and Lord Mance, was that the position should be that there was a short interim period in which effective restrictions would remain in place and during which the Treasury should have the opportunity to attempt to take remedial steps. That is how we understood those two judgments. Now, but in relation to the Terrorism Order 2006, we do seek a period of suspension of the effect of the judgment on that order, and we seek a period of 8 weeks. The reason we do so is summarised at paragraph 13. Firstly, there remain persons, some 13 persons, who are subject to designations under the 2006 order and no other order. And so the effect of the judgment, if not suspended, would be to remove restrictions from those persons forthwith. Also, the position we say should be considered in respect of the Terrorism Order 2001 and the Terrorism Order 2009.
I wasn't aware, I must say, that there were people still designated under the 2001 order. I'm not sure we were told that at the hearing, but anyway...
well, my Lord, it is the position, and I apologise if I didn't make that clear, and that was a point that would have been material to your reasons.
I mean, the position is that the 2009 order, transitionals, make clear, as I understand it, that the although 2006 order is recalled or repealed, whatever it is, nonetheless it remains in force as respects any outstanding designations for it, and the same applies to the 2001 order.
In relation to the 2009 order, there's a sunset provision 31st of August 2010. Yes. There is no sunset provision in relation to the 2001 order. But, my Lord, as to the validity of those orders, it is clear that the effect, as day follows night, what you said about the 2006 order will apply equally to those two orders. And it's equally clear that applications will be made by persons such as G, he says he's going to do this, that the 2009 order should be declared ultra vires and should be quashed for the same reasons as the 2006 order. Now, if you are prepared to suspend the effect of your judgment in respect of the 2006 order for a short period, when applications such as those by G are made to the administrative court under the 2009 order, or by anybody else who's subject to the 2009 order or the 2001 order, it will be open to the Treasury to say to that court that although it accepts the judgment of this court, and for similar reasons the 2009 order should be quashed, nevertheless the effect of the court's judgment should be suspended in the same way that you agreed to suspend the effect of the judgment on the 2006 order to permit a sensible period of, as it were, standstill while remedial measures are taken. As I say, this is a significant matter. As we say in the written document, there are some 25 organisations and entities who remain designated under the 2001 order and no other order, and there are some 21 persons who are designated under the 2009 order and no other order. Clearly, an immediate disapplication of all restrictions, unfreezing of assets and everything else from those persons, is a point of significant importance. As I said earlier, designations are not decisions that are taken lightly, even though the standard applied is a standard of reasonable suspicion. This is a genuine issue of public interest. And so we say that for that reason, this suspension should go further than that envisaged by my Lord Mance and Lord Hope, in that it should apply to the 2006 order and should do so for a period of 8 weeks. The 8-week period takes into account, firstly, the intention to address the issue directly in primary legislation and the need for a sensible period of time for the parliamentary stages of that legislation to be considered. So they shouldn't all be rushed through on a single day, and stages should not, unless it's absolutely necessary.
Is the clock running now? Because supposing we weren't able to deliver, to issue an order today, supposing we were to say, well, we've got to think about this, write about it, and so on, can we subtract from your 8 weeks the number of days or whatever it is that it may take for us to reach a finality?
My Lord, yes. You will see that the draft order we propose inserts specific dates. We don't ask you to vary those dates simply because you've reserved a judgment.
Right. Thank you.
Action will be taken one way or the other.
Yes.
My Lord, as I say, it takes into account a sensible, albeit very short period of time for the necessary parliamentary stages. It also takes into account the February Parliament recess between the 11th and the 22nd of February, which is an immovable object. My Lord, in relation to the Al-Qaida order, as the Court understands, the proposed remedial steps are slightly different. What is proposed is secondary legislation under the European Communities Act to give effect to obligations under Article 10 of Regulation 881. That is the obligation on Member States to implement effective, proportionate and dissuasive sanctions for infringement of the restrictions within Regulation 881 itself. A period of 6 weeks is sought. The proposal is that an affirmative resolution procedure should be used. That will involve, firstly, scrutiny of the draft order after it has been laid by 2 parliamentary committees. First, the Joint Committee on Statutory Instruments. Secondly, the Delegated Powers Scrutiny Committee. This is set out at paragraph 15 of our document. Can it
be amended as a matter of interest during that procedure?
No.
It can't, no.
One goes back to the beginning.
Under the European Communities Act, does it have to be an affirmative resolution procedure? No. It doesn't, no. But it can't be amended, which is the great defect.
And my Lord, you'll also understand why the commitment is to an affirmative resolution procedure.
Yes, of course.
In light of the reasons given by this Court.
Yes, of course.
The 6-week period takes into account the scrutiny by the 2 parliamentary committees, a sensible period of time between the date on which the draft order is laid and the date on which the debates in each House of Parliament will take place, and also the February recess. And, my Lords, we do note that, that in the judgments, my Lords, Lord Hope and Lord Mance were prepared in relation, as it were, to the standstill period to accept the possibility of a standstill period of a month. You will note that in relation to each of the suspensions that we seek, it goes very shortly beyond that. In relation to the Al-Qaida order, the 6-week period reflects really the month plus the parliamentary recess.
I think it's fair to say that when I wrote that period, I did anticipate that it might be a matter for discussion as to whether 1 month was sufficient.
But well, overall, what we say is that the periods that are sought are no more than is considered necessary, balancing need for reasonable expedition and the need for proper, albeit short time for parliamentary consideration. And so this is a situation where, in light of the comments made by this court, what the Treasury wishes to do is to address matters in the manner that this court says they should have been addressed. That's why we seek the suspension. We say that that has to be a good reason in the circumstances of this case. I apologise. Oh, sorry. I apologise for taking so much time this morning. Unless I can assist you further, those are my submissions.
Thank you. We're going to have a very short adjournment, but before we do, it would be helpful if Mr. Bailey and Mr. Hussain could give some indication of the length of their submissions.
My Lord, I'm not expecting to be more than about 20 minutes.
Yes.
I'm going to be very short, my lords, my lady.
1 minute. Right, but we'll still have a short adjournment.
My Lords, my Lady, dealing first with the point of principle, the court's power or jurisdiction to suspend or postpone the relief. On behalf of G, our position is as follows. We do not feel able to maintain that the court has no power or no jurisdiction to postpone or suspend relief. The court has power to postpone or suspend any relief that it is going to grant. The fact that that relief is of retrospective effect does not undo the court's power of suspension or postponement. So to that extent, we are agreed with the Treasury that there is a power or jurisdiction to suspend relief. The question then becomes, what would be the effect of that? In order to answer that question, the court must decide whether, in fact, its judgment speaks for itself at all. Mr. Swift's position is that the judgment does not speak for itself at all. Until the declaration and the quashing order is made, what is said in the judgment, notwithstanding that it's a public authority, the judgment does not speak for itself. Therefore, if a suspension were granted, the fact that yesterday the court handed down its judgment is of no effect. In other words, a person could be prosecuted during the suspension period, even though it is now known that retrospectively that period will be declared to be unlawful. So, my Lords, if the judgment does not speak for itself, if the judgment does speak for itself, then plainly the suspension has no effect at all. If, however, the judgment does not speak for itself, and the judgment doesn't take effect until relief is granted, then what is the position during the next month if a suspension is granted? Well, Mr. Swift sets out the options. Firstly, as concerns a civil claim, no civil claim could be brought now because the relief has not been granted and the order remains in force. But if a civil claim were brought the day after, on the 26th of March, that claim would be valid and could be a fully retrospective claim going back to 2001. It could be a claim based on Article 1, Protocol 1, Human Rights Act damages not in accordance with domestic law. What's the position as regards criminal proceedings? The position, I think, must be that if the judgment doesn't speak for itself, but a person breached the order between now and the 25th of March, they could be prosecuted, but that the prosecution would be stayed as an abusive process because it's known that the court will be retrospectively declaring the law invalid. As to the degree of chaos or order that creates, that's really a matter for the court, in my submission, to assess. But that must, in my submission, be the position. If the judgment does speak for itself, then plainly suspension of relief is academic. If the judgment doesn't speak for itself, then those are the options.
Well, the prosecutor might not bring proceedings, really. I mean, there wouldn't be much point, because I absolutely see your point that the proceedings would be stayed. It would be a waste of time and money to do it.
My Lord, and no doubt there could be a judicial review of a decision to prosecute based upon the fact that a stay would be inevitable and so forth. But that must be the position if you did grant a suspension.
Doesn't it go a step further? Because you said if yesterday's judgment is of no immediate effect, someone could be prosecuted during a suspension period, but leave aside the question of a stay of the prosecution as an abusive process, there would surely be a defence, because the person would be entitled, quite irrespective of any decision yesterday, to re-argue all the same points and say, this is invalid. So he doesn't need yesterday's judgment or any order. And similarly, you said during the suspension period, if yesterday's judgment is of no effect, no civil claim could be brought. Why not? The civil claim would simply say, irrespective of yesterday's judgment, I have been wrongly restricted in my liberty for years. I still am being. you prove the justification for the restriction, and all the matters will be argued again, even if no one drew up yesterday's order, and could be argued.
Well, my lord, the tension there is, of course, between the fact that the law under which you are prosecuted, the time at which you breach the law, if the judgment doesn't speak for itself, is valid. If you wish to argue that it's invalid for the reasons that the Supreme Court gave, if that's the point my lord is making, in other words, in criminal proceedings, I were to argue, well, yes. The law, but the law.
But someone forgot about yesterday's judgment. You could in a magistrate's court argue all the same points all over again and take it up to the Supreme Court.
Well, my lord, I mean, as a matter of practicality, whether you get here again before the 25th of March is unlikely. But that's really neither here nor there. But I take the point, my lord. It may be that therefore you'd be seeking to relitigate this case based upon the judgment, even though the relief left the law in force. So perhaps that's an additional layer of chaos.
But what the relief did was nothing. If no relief has been granted, it does nothing. So the question is, what's the current state of affairs?
Yeah, well, it's also possible to test the proposition as follows. Imagine the court, as I think my Lord Brown, when he was in the Court of Appeal in the Serger case, which is in the bundle, said, well, it's a public authority. Why doesn't the judgment speak for itself? I don't need to grant any declaratory relief. But we're not in that position, since the parties are agreed that relief must be granted as of right. So, of course, the position might have been that your lordship said, we think the judgment speaks for itself and we don't need to grant any declaratory or other relief. But that isn't the position we're in.
But we could be changing our mind.
Well,
not about the fundamental substance, but about what we do about it.
Well, lady, the learned friend's position clearly depends upon the judgment not speaking for itself. If the judgment does speak for itself and does in fact take effect from yesterday, then even if you're minded to grant a suspension, that's of no legal effect.
But that is, if I may say so, a traditional or quite narrow view of the judicial function, which other courts appear not to have adopted. We have actually a choice whether we go that way, the Australian way apparently, or whether we go what might be described as the Canadian or the European Court of Justice way, which appears to contemplate and permit the breathing of a certain amount of life, as I put it, into an order.
My Lord, at the end of the day, in my submission, retrospective relief, such as a declaration, will always create some sort of chaos, as it were, as a result of declaring what occurred in the past, the legal fiction, to have been different. And that chaos is increased, obviously, if the granting of that relief is postponed. And that's why we sought in our written submissions for the court yesterday to focus upon the need for such relief in G's case. So I don't think I can take my submissions on the point of principle really any further. As to whether they are needed in G's case, my lords, my lady, we submit that the appropriate course is to give effect to what was said in the judgments. And the judgments were quite clear.
These are the submissions you made yesterday.
They were, my lord, and I certainly don't propose to repeat them for the full court. In essence, they are in summary that the court said quite clearly that the Terrorism Order 2006 should be quashed. It did not mention a stay in respect of G or anybody else in the judgment. As regards the Al-Qaida order, the court said on at least 4 occasions that it would have suspended the order against G, but for the fact that he was subject to the 2009 order. Mr. Swift says, but we could run off tomorrow to the administrative court and get the 2009 order quashed based upon this judgment, but your lordships will have had that in mind when you made the observations that you did. in my submission.
It's quite clear from what I said in that paragraph that I had in mind that the Administrative Court might actually give time to the Treasury to consider their position. I did say that.
You'll
Before the
have to
Administrative Court to consider.
You'll have to fight your battle there.
That's what
Yes,
I'm saying.
plainly, what wasn't open to you to quash 2009 because it wasn't formally before you, and the directions against G were only made 2 weeks after the hearing. But the comments that were made about the 2009 order were made alongside the comments for the need not to suspend as against G. And so my submission, the relief as against G, should reflect that. So in short, our position is whether or not there is any general need or power to suspend, there's none so far as G is concerned. Unless I can assist.
Thank you. My Lords, my Lady, I think I indicated yesterday that our position on the general question of principle was one of neutrality. My instructions, having taken instruction overnight, are, you might think paradoxically, to support Mr. Swift's submissions. We agree that the court has power or jurisdiction. We also agree that the court's judgment isn't self-executing and there needs to be an order, and that the court shouldn't change its mind on that issue, the point that my Lady Hale raised, for the reasons that Mr. Swift gives. The question on what happens as far as a civil claim is concerned or criminal proceedings brought in the interim, we agree are anomalous, but I think as Lord Bingham said in the torture case, the common law is not intolerant of anomaly. As far as civil claims are concerned, there would be no shield retrospectively from the future date from March, but presently there would be a shield. We say, as far as criminal proceedings are concerned, we say that it would be irrational for the director to proceed with the prosecution, and exceptionally this would be a case where judicial review would lie. A defence would also be available for reasons given by Lord Mance and on Boddington principles, as well as an abuse being available, abuse of process argument being available. The reasons we support Mr. Swift's submissions are essentially because we welcome, on behalf of AKM and Hay, the opportunity for proper parliamentary scrutiny, and we prefer that to emergency legislation which may acquire a momentum of its own. And AKM all remain subject to the 2009 order. Hay is listed pursuant to the 881 regulation. My Lords, those are my submissions.
Thank you.
My Lords, may I 2 minutes in reply? As regards whether an order is necessary, with respect, it's not a question of how obvious the conclusion is from the judgments. It's not a question of whether the judgments are written clearly or written obscurely. The question concerns the substance of the effect of the judgment, how important, what is the matter that's being decided. In the Perjure judgment, Perjure case, which is the case that Mr. Bailey referred to, which for your notice at tab 3 of the authorities, the point that my Lord Brown was dealing with, in particular at paragraph 73 of his judgment, was a situation where, in the course of losing an argument under Article 14, at one of the stages of that argument, the claimant had succeeded. And the claimant was saying the judge below should have granted a formal declaration to say that we succeeded at that stage, even though overall we lost the Article 14 claim. And the point that my Lord Brown made at paragraph 73 of his judgment was to the effect that he didn't find the claimant's position persuasive on that, and it was in that context he made the observation that very often the court allows its judgment to speak for itself rather than grant express declaratory relief. Why should that not be so here? Now, that's a very different context to the present case, where the consequence of the reasons given in the judgments is that secondary legislation will be quashed, will cease to be lawful, will cease to apply. That is a consequence which we say needs to be dealt with and recognised in a formal act by this court, and the formal act is the order. And so it's not simply, as we say, a question of how obvious or how obscure is the language that the court has used. The real question is, what is it doing? and it's because of the significance of what you are doing, the widespread consequences of that, because you are removing provisions of general law, those are matters that need to be reflected in a formal, effective order. My lords, thank you.
Well, this is the second important ancillary point of general interest that this case has spun off. We're grateful to Council for their submissions, and we will take some time to consider our judgment on this point, which, of course, while we're doing so, has the effect for which you seek.
Whatever that means.